federal posts as well. The way the Constitution is written is the Supreme Court is the highest court within the land. Inferior courts are then, and inferior meaning that they're below the Supreme Court, are then created by Congress. So when you're talking about like the circuit courts, the Ninth Circuit, for example, is what we're under, I believe. Judges were to hold office during good behavior. And again, they're immune from pay cuts. Again, it's this notion of independence. Congress couldn't penalize a judge, or the executive couldn't penalize a judge if they weren't behaving exactly the way that branch of the government wanted them to behave. The good behavior is kind of interesting because in, can't remember right off the top of my head, in one of the Federalist Papers, Madison wrote about public office holders in general, servants of the public. And he also used this term good behavior, that any individual serving within the government should serve under good behavior. When you're talking about kind of the breakdown of what the enumerated powers were for the judicial system, it's talking about cases, and cases typically are referred to as lawsuits. That was their major concern, is judging disputes between either individuals, between states, between foreign powers in the United States, between foreign powers and states. So there's a whole list of different kinds of cases, examples of what the enumerated powers are for the judicial. And some of the ones I listed here: law and equity arising from federal law, cases involving foreign diplomats, admiralty, maritime cases, cases where the U.S. government would be a party, between two states, cases between state citizens and another state. So they tried to cover all the bases. Of course, they can't cover everything. Judicial review is a concept stated in the Constitution. It talks about, well, the notion of it is that a judge might encounter a state or federal enactment of law that is unconstitutional, and they can then render it as being unconstitutional. Of course, in our system, if a lower court rules that something is unconstitutional, like Obamacare, it has to make its way up to the Supreme Court before it gets its final hearing and the final determination. This was a concern for the Anti-Federalists. They felt that the judicial could have too much authority over the Constitution. They could manipulate the Constitution and have too much authority over federalism and states' rights. But the founders expressed during the pre-ratification debates and the ratification debates, they put forward this notion that judicial review is an important aspect of maintaining constitutionality, of maintaining the purpose of the Constitution and the authority of the Constitution. It also helps protect the supremacy clause, the notion, and we talked about this, I think, the very first night, that the supremacy clause talks about that the Constitution is our supreme law of our land. Under that comes federal laws and treaties. Under that comes state laws. Under that comes local laws. So, for example, if some state was silly enough to say that they were going to take on federal responsibilities and protect the border, that would could be ruled unconstitutional. Limitations on power, and I apologize. I think I grabbed the wrong file when because these are part of my notes, but actually there's a couple slides here. There's some information missing. Congress actually has some authority when it comes to the Supreme Court, something I was actually not really that aware of. I'm not a legal scholar as far as that goes. But they can basically restrain the Supreme Court when it comes to their appellate kind of jurisdiction, if you will. I'm not sure how often they've done it or whether they've done it lately, but the Constitution does grant Congress some control over the federal government, or over the judicial branch, over the Supreme Court. And that's it. So tonight was pretty quick. Any questions?